Let us begin with the session. So our session is all going to be about how to draft a contract. We will be dividing this all session into three parts. Okay. First will be what is a contract, because we need to know the basics of it before getting to the complicated part. We should know the basics of it. Then what are the essentials to make a contract? And at the last but not the least, how to draft a contract. Okay. Now what is a contract? अगर हम लेमैन लैंग्वेज में बात करें, बिल्कुल सिंपल वर्ड्स में, तो कॉन्ट्रैक्ट क्या होता है? तो what I was trying to say is, let's assume that we have party A and party B. So party A offers another party, that is our B. Uh, let's suppose they want to sell something, and the party B agrees to that, and they are going to give them a consideration in exchange of that. Something they are going to pay in exchange of that. The payment can be money, it can be a valuable item. What is a contract? So, in a layman language, do you all understand? Give me a thumbs up. Okay, thank you. Let's go with it. So a proper definition for it is an agreement made by free consent between two or more parties. Remember, it is two or more parties, because if there is only one party, there cannot be any agreement, which is enforceable by law and involves a lawful consideration. What is a lawful consideration? Any payment which is done in exchange for the goods and services, let it be money, let it be any valuable property, is known as consideration. When it comes to lawful consideration, it is something which is not illegal. For example, money, gold, anything which is legal by the terms of laws, it is lawful. In exchange for goods and services is known as a contract. I hope this much is clear for you. Let's move further. So now there's a major difference between an agreement and a contract. Okay, so an agreement, where is a very basic thing. It is something merely a promise. It can be merely a promise from one party to another, but a contract is more of a formal thing. So let us read what is the meaning of it. The meaning of an agreement can be acceptance made by one party to the offer from another party. As I said, there is an offer from party A, and then there is acceptance on the behalf of party B. Remember, there are two important elements of it, which is acceptance and offer. On the other hand, the contract is an agreement. It is already an agreement. That means that there has already been acceptance and offer from the parties. So an agreement which is enforceable by law is a contract. Now, proper definitions according to the Indian Contract Act 1872 are every promise and every set of promises forming the consideration which each for each other is agreement. Now this is given in section 2E for the of the Bear Act, and it defines agreement. Now section 2H of the Indian Contract Act of 1872 defines a contract as an agreement enforceable by law is a contract. This much is clear? Give me a thumbs up. Thank you. Now, what are the essentials of a contract? So, first of all, there has to be two or more parties, as I said. Then, one party should make an offer and the other party must accept it. If they reject it, there can not be any further process of the contract. So, there must be an acceptance. Okay. Then, there has to be a legal relationship formed between the two parties. That means everything should be documented, everything has to be legalized by them. And then a lawful consideration must be included. As I explained in the previous PPT, what is a lawful consideration, and it must be there. Then you must remember, before all of these things, The parties must be competent. Now, what competent means is the parties must be major and of sound mind. And once all these requirements are fulfilled, the parties must agree to it with free consent. So now we were going for free consent. Now, free consent is something which should come by, there is no coercion on the parties, there is no undue influence on the parties. It is a free will of a person. Let's go further. Now, these are some landmark judgments related to the same. So, first we'll discuss Harvey versus Facey, and it defined the difference between invitation to offer and what is exactly an offer. We'll not discuss it in the deep because we do not have that much of time, and this session is about drafting basically. So, I'll suggest you all to take a screenshot of it. And the second landmark judgment is Lalman Shukla versus Gauri Dutt, in which they talked about the knowledge and communication of the contract. Now, third, we have Balfour versus Balfour, which is a very famous landmark judgment, and it gave legal reaction theory. I would request to you all to go through what is a legal reaction theory. You will definitely find it interesting. Now, how to draft a contract finally. So, first of all, when you are drafting a contract, you should remember a few things, and there are a few things that must be mentioned. So, these are the few things I'll be explaining to you. So, first of all, you have to define the parties one by one. Okay, you have to define their names, their address, and their contact information. For example, email address or maybe the number. Okay. Uh, of course, you'll have to ensure that the parties have the capacity to enter into a contract, that is, they are of sound mind and they are major. Next we have is a preamble. So now what is a preamble? A preamble is something which is a sort of a paragraph. Okay. This paragraph is basically consists of parties to the agreement, date, and the key benefits expected, the goods and services provided may be. Okay, so this is an introductory paragraph. It consists these basic informations, not in detail, of course, but these basic ones. Up until now, everything is clear. I hope there is no confusion on anybody's part. Okay, thank you all. Now, define the purpose and duration of the contract. When you are writing a contract, when you are drafting a contract, you should clearly state the purpose of the contract, whether it is a offer letter for something, whether it is a rental order, whatever the contract is, whatever the purpose of the contract is, you'll have to write it clearly without any ambiguity, including the scope of work, goods and services provided, and the duration of the agreement. Of course, remember, you have to mention all of these things very accurately and clearly. Now, you have to, after you have done all of this one by one, you'll have to define the terms and condition of the contracts. Now, what are the terms and conditions? What can be the terms and conditions for the same? Okay, for example, there are some specifications according to the wishes of party A. For example, let's assume that I am party A and one of you guys is party B. Okay, and I want to sell my car. It is a red car with the big giant wheels, and one of you is very much interested and accepts my offer. So we have to clearly mention that I am going to sell my car only if you give me 500 rupees in the consideration. So now it becomes a condition for the contract, right? So you'll have to specify the conditions for the same. Okay, I hope this example clears it. But let us discuss what are the important parts of the terms and condition. What are the essentials of terms and conditions that you must mention and must not forget? Okay, there is payment terms. Now, what is payment terms? However, the payment is going to be done. For example, what is the schedule for the payment? Okay, after 1 week, 2 week, a month, what is going to be the schedule for the payment, what is going to be the method of the payment, what is going to be the amount for the payment. Now, delivery and performance dates and timelines, when the delivery must be done, when the performance must be done of the contract, you have to specify it, and the timeline as well. Now, quality standards and specification. Now, let's assume that one is working in a medical line, and a contractor has to sell the medicine to one specific company. Okay, so now it has to take care of all the standard uh, quality checks and specifications that they mention. So any such specifications and standards, they have to mention in the contract. You have to mention in the contract. Now, warranties and guarantee. Let's assume that you have bought something, bought a bike, a good bike you have bought, and it has a warranty of 1 year. That means you'll get free services for checkups and everything, right? So any such warranty and guarantee you must mention in the contract clearly. Now, what happens if all of these things happen and then there is a dispute? What are the things that you must follow, what is the procedures you must follow? So these procedures, in case of a dispute, if party A has a dispute with party B of the contract, then there must be a procedure mentioned in the contract to resolve that dispute. So a dispute resolution procedures you have to mention. Then there has to be a termination clause. For example, I am a contractor and I want to terminate the services that I'm taking from one of you. For example, there is Raju who is giving me goods and services, let's say, and I do not want his services anymore. So, what is to be done? What is the procedure for the termination? You must mention that clearly. Remember that everything that you mention must be clear, concise, and unambiguous. Unambiguous means there must be no confusions, no double meaning to any statement. If there is any statement that might have any meanings more than one, then you must specify that this particular sentence must be taken in this particular sense only throughout the document. Understood? Can I get thumbs up? Thank you. I hope this all is clear to you. Let's go further with it. Now, define the consideration. One party is providing goods and services to the other party. Now, what will be the consideration? As you all know that without consideration, a contract is not a contract. There has to be a consideration to it. So you have to clearly mention in your contract which you are drafting that what will be the consideration of it, how it will be exchanged to the between the parties, how it is done, every value and every benefit that you are giving. For example, you are giving some extra perks. Uh, let's say there is Rahul who is working in a IT company and he is getting say 40,000 rupees for his services, and this company also gives cab facilities and meals facilities for him. So now they have to mention in their contract that they will be providing him 40,000 as his salary. Then they have to also mention that they will be giving perks like cab services and meal services. So you will have to be very precise with consideration as well. Now, this is a very interesting part, and you will enjoy to know this. There are confidentiality clauses in the contract. Now, what is a confidentiality clause? So, a confidentiality clauses are the terms and conditions for the secrecy and confidentiality of intellectual and physical property or any other information related to any of the parties. For example, if I am working with law article, all the intellectual property or the physical property has to be, or any information that they do not want to share with the public, it has to be mentioned in my contract, in my job letter, that I must not share it. So this is, when you mention this clause is specifically known as confidentiality clause. Now, non-solicitation clause, let's say there is a teacher, V, and he is working in a school, and now he has been working for 10 years and he is loved by his students. Okay, now he has some money and he opens his whole school. Okay, now he has opened his own school, and now all the children are going to him instead of their previous school. So this is called solicitation. So there are specific clauses in a contract that you must mention while drafting it, so that a person cannot solicitate any kind of people from one organization to another. Okay, is it clear? Okay, thank you. Now, non-compete agreement is a legal agreement or clause on a contract specifying that an employee must not enter into a competition with an employer during and after the employment period is over. Now, this explains us that if you are
Ma'am, could
working
you,
somewhere,
ma'am, I'm
yes,
sorry, ma'am. Could you please repeat solicitation?
okay. Okay, of course. Are you okay? Let's go with it. So, non-solicitation is something. Let's suppose Manglesh, you are working with law article. Okay. So, and you are organizing this workshop, but the people you have organized the workshop with, they know you very well, huh? And they know that you are very talented. And now you open your own company. Okay, now that you have opened your own company, uh, the people already like you, so they will automatically go to you. So now this is taking an advantage of the platform that you have got from the previous organization that you were working with, right? So this taking the audience from the organization that you were working with previously is known as solicitation. So the employees must not do it. For assuring that, we add a non-solicitation contract clause with them, right? So they must not take the clients of the company with them when they leave the company or for their personal gain. Is it okay now? Do you understand? Give me a thumbs up. Thank you. Let's go further with it. Now, non-compete agreement, we have already understood. These three clauses are a major one because, see, there is non-solicitation agreement and non-compete agreement, which are a big document in themselves. And let's hope we will conduct another workshop for the same, and it will be in-depth knowledge about the same. Okay, let's go further with it. Now, force majeure, it is a French word which means superior force. Now, what is a superior force? Is the have you heard of a word act of a god? Okay, that comes into a total different thing. But in a layman language, to explain you all, something which is you know out of your hands, a condition where you cannot control it. It will happen. It is unforeseeable, and because of this particular circumstances which is unforeseeable, uncontrollable, you cannot provide or you cannot perform your contractual obligations. This all phenomena is known as force majeure. Okay, understood? Okay, thank you so much. Let's move further to this. So now notice clause. Okay, for example, let's not take example and go as it is. A notice clause is something which notifies all the parties to a contract that what is to be done. Okay, there are general clauses. It generally contains any changes in the contract, any information that is to be passed through the parties which is providing the services and all, and manner of search required notice, matlab whatever, and also the termination, not the termination ones. Okay, how should I tell it to you? uh, any clause which mentions that any notification from party 1 to party B, how it's supposed to be delivered to party A to party B, is known as notice clause. Now the notice can be of anything. It can consist of a what you call it, information, termination information, or any other important confidential information from one party to another. That is known as a notice clause. Is it understandable to you all, or shall we move
Yes.
further? Okay. Thank you. Do you have any questions up until now? Up until now, any questions, any doubt, or shall we move further? Okay, I will assume that you guys do not have any doubts, so let's move further. Now, define the governing law. Now, what is a governing law? You have to mention that in case of any dispute among the parties to the contract, what will be the jurisdiction that is relevant to the contract. Now, for example, you live in Delhi and you are working for a company which is located in Mumbai. So, what will be the jurisdiction for law in case of any dispute? So the jurisdiction is to be mentioned in your contract very clearly. So if the company wants, they will be like, we want the laws which are going on in the Maharashtra in our contract. Okay, so it will be mentioned there only that the all the jurisdiction has to be from the Maharashtra state in case of any dispute.
Sorry for
Okay.
interrupting, ma'am. I am Ritika
Yes.
here. Can you please repeat what is notice clause?
Notice clause. Okay, let us go back for once. So
Thank you
notice
so much,
clause is
ma'am.
something. Okay, you have your name was,
Uh, Ritika.
sorry. Okay, hi Ritika. Well,
Yeah.
Ritika, let's say you and I are the parties to a contract. Okay, you are working with me, you are providing a good services to me. For example, you are providing food services to me. Now I want some change in my food. Let's say I want less salt in my food. Okay, now how should I notify it to you? The process of notifying it to you, how should I convey my information to you, right? That is to be mentioned in the notice clause. So that information can be anything. It can be a general information about something. It can be any changes that is done. For example, let's say I have changed my house. So my address is changed and I have to notify it to you, right? I should mention it to you to get continue services from you. So now I have to notify it to you. So how it is done? It is mentioned in the notice clause. It also involves termination. I do not want your services anymore. So I shall notify it to you. That is also mentioned in the notice clause. Is it clear now? Shall we move further?
Yes, ma'am.
Thank you so much. Now, governing law is clear to you all. Give me a thumbs up. Okay, thank you. Now, you shall also define the dispute resolution procedures. Okay, in case of any dispute that arise between the parties to a contract, you shall mention how exactly it is supposed to be resolved. It can be resolved by mediation, arbitration, litigation, ADR mechanisms. Okay, all these things I'm not going to explain because they are a specific subject, they are specific fields in themselves, and let's hope that we have another workshop for the same. Okay, but I would suggest you to Google them once. What are they, how it works for them, and I would also advise you to participate in any competitions that law article might organize or your college organizes related to these specific things. Okay, let's go further. Now that you have done all of these things, now that you have mentioned everything about the dispute resolution, the specification about the parties, everything that you have mentioned, you must review it, not once, not twice, however you want, you should review it. Okay, carefully ensure that everything is written accurately and exactly how the agreement was done between the parties. It must not suggest anything otherwise rather than the agreement which was actually done between the parties. It must not have any other meaning but the same meaning, not even similar, the same meaning as party A and party B wanted. Check all the sentences that they do not have any double meanings into that. Check all the terms and conditions that you have mentioned in the contracts while drafting it. Okay, there must not be any sort of ambiguity when you are drafting a contract. Okay, and then revise it once you have reviewed it, you have checked all the mistakes and everything. As a lawyer, it's your duty to revise them and make sure that everything is clear, concise and unambiguous. Let's move further. Now, after it is all done, then there has to be signature and date of the contract. And each party has to sign and mention the date to the contract in presence of a witness, if there is the requirement of witness, or notary public. The notary is easily available in any district court and you can see it. Must ensure that the sign, remember the signature that you are getting on behalf of the parties or the witnesses, remember that they are not forged, they are genuine. And if they are signed on the behalf of any representative, then they are authorized, they are given permission by the clients themselves that they are their representative and they can sign their contracts. Okay, is it clear up until now to you all? Any doubts? Okay, thank you. Now let us have a look to an actual contract. So now this is a joining letter, as you can see. So this is a company XYZ which has its joining letter given to its employee. So they have mentioned, look, here is the name of the employee, and this you can call it preamble of it. This area you are seeing, is it visible? Thumbs up please. Thank you. So this specific paragraph which summarize everything, that they are offering a job to you in this specific company and they are very excited about you joining them. And it also mentioned that this specific joining letter outlines the terms and condition for your job. Okay, so this is a preamble of this contract. Now, it clearly mentioned the position of the employee. See, the designation of the employee, name of the in charge who will be, reporting to. See, we come to the duration of employment. This is the duration of the contract, right? When it will commence and until when it will be enforceable. Okay. Now salary is what? Consideration. Salary is here our consideration. They have mentioned it very clearly. Now duties and responsibilities. You can say that these are the terms and condition for our contract. That what will be the duties, what services they will be providing, you will be providing, to be precise, to the company, and how it is all to be done. Okay. Now confidentiality. Remember the confidentiality clause we talked about? So they are saying that you are required to maintain the utmost confidentiality regarding all the property or business sensitive information that you may have access to during the course of your internship. This obligation remains in force even after the conclusion of your internship period. Disclose any information unauthorized individual or entity could lead to the termination of the job and possible legal action. Okay, so they specifically tell you that legal actions might be taken in case that you are, sharing any confidential information with any individual who is unauthorized to have it. Okay, is this clear? Can I have some thumbs up? Okay, thank you. Now, working hours, specifying their working hours. So this also comes under the terms and conditions of the contract. Code of conduct also comes under the terms and condition of the contract. Intellectual property. Now, intellectual property is also a part where you have to be very careful while mentioning and drafting your contract. So now what is an intellectual property? It is something that is generated by the intellect of a person. Okay, it can be anything. Maybe it can be a art piece, it can be an invention and or something. So any intellectual property is supposed to be under the name of this company. It is mentioned here. So you'll have to be very precise with this clause as well. The training, they are mentioning how the training will be done. Perks and benefits, it also this also comes under the form of consideration. Whatever the perks will be, whatever they will be, whatever benefits that they will be providing to the employee, for example bonuses, networking event, development opportunities. So all of these perks and benefits also come under consideration. Evaluation, how this also comes under your terms and condition of it, that how the employee will be, evaluated, what will be the standards for the same, who he shall be reporting to, how he shall be reporting to, what is. Now this reporting thing is mostly the notice wala clause, if you remember. This mention how, you shall notify your supervisor how you are doing everything. Safety, security, again the terms and conditions. Non-compete, see we have this clause again. This specific contract I have drafted specifically for you to make sure that this comes easy to you and you are able to understand everything. We will see though the, proper formatted wala document as well. For the duration of your job, a year, and see they are specifying that the employee is prohibited from engaging in any employment consultancy or businesses activity with any entity that is directly competes with XYZ Private Limited. So they are explicitly telling you that you must not involve with any organization who is their direct competitor. Exclusivity of their services, they are asking you that you will not work anywhere else until you are providing us the services. Here comes the non-solicitation part. During your job or for a period of 6 months thereafter. Remember we were talking about how one person must not take clients from the company even after he leaves the job, when we discuss it. So they are mentioning during your job and for a period of 6 months and after. Thereafter, you are prohibited from soliciting business from any of the company's clients or customers for your personal benefits, or the benefit of any third party. Is this clear up until now? Any doubts? Okay. Termination, they are explicitly mentioning the termination, how the services can be terminated. The company reserves the right to terminate you from the job at any time, with or without the cause. Here can pardon me, any time with or without cause means that they may give you a reason, they may not give you a reason. Now you have to be very precise with this. If you do not mention these intricacies of it, it will not work, because if you mention that if you do not mention without cause here, then the whole meaning of this paragraph changes. The condition for the same, that we will not provide you with any reason if we terminate you. If you do not mention this, this will create some problems. This might create some problems in the furtherance future. Okay, so you must take care of these small intricacies of it. Okay, in case of termination, you will be notified. Again, it comes notified in writing, detailing for the reasons and effective date of termination. Amendments. This agreement, okay, this is telling you how this specific contract can be amended. It must be mutually agreed with both the parties, and then only it can be enforceable. Here comes your dispute resolution. How the dispute will be resolved? They are saying that any disputes arising between the party, the employer, and the employee shall be first resolved with mutual discussion, and if and if then it is not resolved, then they can go for through then art. See, they have mentioned arbitration process as per the rules of the state. Now here comes the rules of the state, and they have mentioned what is a state here. So that is mentioned in your governing law. And this agreement shall be governed by the construed in according to the laws of Gujarat state. The laws that are running in the state of Gujarat shall be the governing law. And if you have any problem, you shall abide by the laws of Gujarat state. Both the parties agreed to submit to the jurisdiction of the courts of Gujarat. Remember this, jurisdiction of the courts of Gujarat state for the resolution of any disputes arising out of this agreement. And they also provide, they also mention miscellaneous clause. Any other terms and condition required, any changes, any amendment that are done between or during the tenure of the work, or during the contract when it is enforceable, then all these things are mentioned in this miscellaneous point. Okay, now they are telling you the last part that we discussed. Remember the signing of the contract. Here they are telling you that you will, you are signing this, and how you shall return the copy of it. Now here will be the signature of the employer, I said. Here will be the designation of the employer, name of the employer, and the employer will put his seal or stamp or the signature of himself. The seal of the employer, that is XYZ Private Limited seal. The name of the employee here, I, for example, Muskan Kulshrestha, hereby accept the terms and condition outlined in this letter, and I shall, you know, do my sign over here. Is this, so this was, yes, you have to employee signature and date of the employment you also have to mention. After I have signed here, when you are drafting this, you will give the space for signing to the employee, and you must mention that he must sign over here, like, employee sign, and the date of his employment. Okay, so we have another contract, and this is properly drafted for you all, how it should look like. So it has, this specific preamble for you. There are recitals in the same which mention how it is to be served and all. There is definitions, scope of services that are to be provided, the term, that is the duration of it. I hope you are all understanding it, as I have already explained the previous contract. Now it is, I think that it will be more understandable for you all. Can I get thumbs ups from you all if you guys are understanding? Thank you so much. You all are understanding it. I'm actually glad about the same that I'm able to explain it to you all very nicely. If you guys have any doubts, you can ask right now. You can leave it in the chat box, and we'll take the end of the session, the last 5 minutes of our session for Q&A session. Okay, so there is this term, and they have mentioned, look, they have mentioned 3 and then 3.1. This is how you exactly write it, how clean it should be, how precise it should be. See, first day of July 2024, they have clearly mentioned the date. They are being very specific, which clause you are supposed to follow, how it will end, you have to be very precise like this. The payments term, here it comes. The payment, in what kind of, if it is Indian rupees, it is in US dollars, whatever the kind of currency you are using, then the amount is specifically schedule in installment, or it will be in one time. Confidentiality comes again, the information and the exceptions they are also providing. Intellectual property, the ownership goes to the company from the client. The client has no authority over the intellectual property that he is doing, or any other work that he is doing for the company. The termination is clearly mentioned. Then there is governing law, which state or city specifically. Okay. Dispute resolution, as we already mentioned in the previous contract as well. Arbitration they are mentioning specifically. Then the last, miscellaneous. There is also severability. Okay, so severability, if any provision of this agreement is held to be invalid in or enforceable, remaining portion. Okay, 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 okay. So severability here is specifically specify that, for example, any agreement, you have made a contract, it was legal, and then suddenly there is a change in law. Now it is not legal anymore. Or let's hope that, let's imagine that we have come into a contract. I will sell you cold drinks. Okay, I will sell you cold drinks, and one of you, for example, Ritika, I remember your name. So Ritika, I'm selling you this cold drink, and I'll take money or diamonds from you. That is our currency for this, contract. I will sell you cold drink, and you will pay me in diamonds. Now selling diamonds becomes illegal, or it was already illegal, or it was not, valid, or it was unenforceable. Now in this case, the whole contract does not get illegal or invalid. It becomes, the only portion that is invalid, that will be, put aside, and the points which are valid, the part of the contract which are valid, shall be enforceable. Is this clear to you all? Give me thumbs up. Okay, so here is the space given for in the witnesses, for witnesses. Now you can see the name, title, and corporation. This is our client, and the client must do his signatures here. Then the service provider, shall make his signature here. Now the description of services at the end of it, and much more intricacies of it. Now this is how your contract should look like after you have drafted it. All these things which I have mentioned below are very necessary for you all to remember while drafting any contract. Remember that if for the first time you draft a contract, you might, do mistakes, but you must not take them to your heart, because this is something which comes with practice. You must remember what you should mention, all of it. Be very clear, keep on practicing, be aware of what laws are to be followed, and what the terms and conditions were of the parties, what were the terms and conditions of your specific client. then you must be able, then you will be able to, draft a contract like this.